impacting, in other words, their thought processes by threatening them with death and their written communications. And so rather than be more divisive and creating more conflict, then we've decided to ignore the opportunities that people suggest we take quickly and radically to resolve this problem. Mr. Pruner and I just briefly, as he stands on the other side of the screen or sits there, but we just decided that to chat a few minutes. We always have, even in the toughest of cases, about Rule 3840 process, and that is delineated, clearly that this is a first appearance, at which time, with or without opposition, this court can enter the rule to show cause, and then it goes to the necessary secondary phase in Part B of the rule, even the responses, motion, statement of particulars, partial discovery almost implicated in it. Likewise, then there's an arraignment, a hearing. So this is not today is not technically a trial, but the reason, because of the nature of the case, and not suggesting that this court would not follow the rule, but having seen everything in so many places, both here and far away throughout this country in cases, I want to make sure that we had something on the record already addressing these issues because of the critical problems that we face in the case. So, admittedly, they knew when they went that they were not going to answer questions that would lead to the execution of their son. And that would be something that we may have to deal with, because that has an impact. And I'm not suggesting they have any direct knowledge, but then I'm not suggesting that they don't, because then why would
They're like halfway through the bushes.
Coming to our knowledge.
Yes, exactly. You just got to keep walking and drinking water.
Yep.
What happens here is that the nature of the question, and I told Mr. Pruner, and again, it's hard because it's easier to deal with a prosecutor that I'd rather have it the other way, where the temper's the way it is. It's also great that he knows law. And so when we spoke, I from the nature of the questions and so forth, I perhaps said we'd live to fight another day in the case and perhaps agree or disagree as to some of these issues. But, I have framed the response. I have been candid, I hope, or shall I say Ms. Edwards from our office has been candid, I hope, in the expression that the position I take, if it gets to some of these things, is a minority position, but letting kind of the cat out of the bag, which is the process before this court, the threshold questions, and after the notice I gave him there would be no answers to the questions of substance, we can't even evaluate the real privileges that may lie that are enumerated in Chapter 90. And the reason is because there may be spousal privileges that need to be overcome. What if there were discussions between them about observations, not necessarily about acts or evidence? What if they formulate opinions unfounded in medical evidence of any sort that they discuss? So all of that would follow to perfect something that I don't know. But I can assure this court that the community interest in finding out what happened is equally as important, and most good lawyers would say not as important, but it's equally as important as the preservation of due process in the case and the Donaldson's ability to reflect upon some of what is taking place. And Mr. Pruner was efficient in terms of their condition or his condition when I was present. The transcript likewise reflects the same for the mother, to establish whether there were any problems and so forth. But Mr. Pruner, thanks, I guess, in part to my, I wouldn't call it interference, thanks to my position, was unable to ask questions such as, have you slept for 4 days? You know, do you know where you're at? Meaning, like, likewise, would have led perhaps, and I know he's professional enough to do that. So we would have objections to the final goal, because no matter how it's perceived, it's testimony that is being elicited to make a determination for their son. You have everyone on one side, I guess, that wants is how to cogently, fairly, and efficiently arrive at those answers, because let no one's. At the same time, nothing that I say is to impact the guilt or innocence phase of Ms. Holt's representation. I've made it abundantly clear, by the way. And I did want, as I close, to alert the court to how, you know, this particular, and also Mr. Warren, who's again behind the screen, and I'm sorry that I'm not having eye contact with you, but to alert him to the fact that how this came about in the selection process, which is accurate, and many people suggested that they wanted to be part of this team, would fund this. A lot of the old legends that, you know, over the years we have met in courthouse steps and so forth. And so then I had to look at the best team available. And it's a local case. It's a local matter. And so that's why I selected Julianne Holt and her staff. So I don't, now having delegated, shall I say, that responsibility, I certainly don't want to say anything that would impact their case. Thank you, Your Honor.
Thank you. Mr. Guzman, Mr. Shafi, any follow-up?
No, Your Honor. Your Honor, we provided the state, and I believe, Your Honor, with our motion to adopt the facts and arguments that provided by Mr. Fernandez. And once again, on behalf of the family, you know, they understand. They are very sorry about everything that's happened. Everybody's a victim in this matter. And it's been a very harsh reality that they've had to live in, and repeatedly they have expressed their sorrow to the community, to the victims, to the individuals, to the police force, and to the Seminole Heights community.
Mr. Pruden?
Just in brief response, Your Honor, I would emphasize that the only issue before Your Honor today, and the only inquiry I suggest before Your Honor to resolve, is whether the state's pleadings and the exhibits attached thereto set forth essential facts, in this case, the Donaldson's refusal to answer questions that would potentially comprise indirect contempt. And we would ask Your Honor to make that finding today based upon the pleadings that have been unrefuted at this point.
And Your Honor, by stipulation, I would agree that on their face, they are sufficient for the next step in the process.
All right, Deputy Deal, can I borrow you for a moment, please?
Yes.
You would give 2 of those to each of the defense counsel and 1 to two of those to the state for me, please. Okay, so maybe it's a situation with this division, but this does seem a pretty fast-moving case. And there's not, as both parties I'm sure are aware, there's not a whole lot of case law with these issues. I was able to find a court order from Miami Judge Milton Hirsch, which I think is really, really well written. And so there are a couple of things from his order, which I just gave you copies of. And I'm going to put on the record, and then I'll issue a written order later. I mean, he talks about, in the case that he had, which is State of Florida versus Charles Romero. It's a June 8, 2016 order, where the state was requesting an order to show cause for a witness or a victim that refused to appear. And Judge Hirsch goes through whether the court should go with indirect criminal contempt or indirect civil contempt, and there is a difference. On page 2, he talks about, and I'll read from section 2, paragraph 2. He says, to initiate criminal contempt proceedings is to initiate a criminal case. We'll drop down to the next sentence, next paragraph. As with any criminal case, the initiation of a criminal contempt proceeding may have collateral consequences. And then the final paragraph there. By contrast, the purpose of a civil contempt proceeding is to obtain compliance with a prior order of the court. And that is why I asked the state what their end goal was. Was it to punish the Donaldsons and to potentially make them convicted criminals as a result of the actions of this past week? Or was it to gain compliance with the court order? And so, indirect civil contempt, and Judge Hirsch goes through this, and like I said, I'm going to adopt a lot of his language in my order, but he goes through a lot of this. And with indirect civil contempt, there's a purge. The defendants do not become convicted criminals, assuming that would happen at the end. And I'll turn to, I believe it's page 3, the 4th paragraph, and he writes, the purpose of civil contempt is not to punish, but to coerce the contemptor to do that which the complainant, in this case the prosecution, seeks, and to which the complainant is entitled. And, is the state entitled to this? And the answer to that question, at least based on what the court has reviewed right now, the answer is yes. In fact, Judge Hirsch, if you turn to the first page, he talks about in the very last paragraph on the first page, and he references a second DCA case, Imperanto versus Picola, Florida second DCA 1970 case, that the prosecutor can be a one-man grand jury. And the quote that he says further down, maybe the next page. Yes, okay, so Judge Hirsch writes on the top of page 2, and I'll quote Judge Hirsch on this. So far as I'm aware, this all but unlimited power, and he's talking about subpoena power, is exercised by no other prosecutor in the American system, not even an assistant United States attorney. So the state attorney's office has great power with these subpoenas. It's clear they have that power, and it's clear they can subpoena Mr. and Ms. Donaldson to answer questions. So at this point, that's what I'm going to do. And I will order Mr. and Mrs. Donaldson to appear before this court on, I believe it's January 5th is a Friday. Is that correct? Yes. I'm trying to give enough time with the holidays, and yes, January 5th is a Friday. Okay, so on Friday, January 5th, at 10 o'clock in this court, to show cause why they should not be held in civil contempt. Both Mr. and Ms. Donaldson can purge the contempt citation by appearing in the office of the state attorney at any time during the regular business hours in the intervening time period, and testifying truthfully under oath regarding this case. And I'll just follow Judge Hirsch in the bottom of his last sentence of this order. And the office of the state attorney is directed to arrange for the service of this order to be made on the Donaldsons within a reasonable period of time, and I'll write up the order.
Yes, Your Honor. May I ask one question of Your Honor when you're completed?
I'm done here.
Finished, I mean. Upon our receipt of your orders in this case, and I guess this is indirectly directed to defense counsel, would they agree to accept service of those orders upon counsel rather than require us to personally serve Mr. and Mrs. Donaldson?
Yes, Your Honor, of course.
Great.
Thank you.
Okay. So Any other issues that this court needs to consider at this time?
No, Your Honor.
No, Your Honor, none from the defense.
Okay, all right, thank you. Everyone have a wonderful day.
Thank you, Your Honor. Thank you.
All right, go ahead and get the steps out.